So students, today we are going to start with some of the introductory portion of the topic of agency. The first one is kinds of agents. So now we can have different kind of agents. First one can be express or implied. So already we have discussed about the mode of creation of agency, wherein I discussed in detail the express agency and agency by implication. So it is just the same. The second is general, special, or universal agents. General agents are those agents who are performing generally the all the tasks which belong to the contract of agency. Whatever task was handed over to them by the principal, they have to perform all of them, all the matters which are concerning a particular business. But in case of special agency or special agent, the agent is required to perform only a specific particular task only. For example, if I have appointed a person as my property agent to sell my house, so in that case, he will be a special agent. Now, another person I have appointed to look after my business in my absence. So will be doing each and everything which is regarding my business. So he will be a general agent. Third one will be universal agent. Universal agent is the one who will be doing certain acts on behalf of the principal, which are business transactions or which are his non-business transactions. So his personal task or his business task all will be handled by the universal agent. Third category is agent or sub-agent. So we are going to discuss in detail this topic of sub-agency in the forthcoming topics. So I'm leaving it for the time being. Fourth is agents can also be mercantile agents or they can be non-mercantile agents. Mercantile agents are those agents who are representing a principal in their business transactions. And the non-mercantile agents are who are representing you in your some other capacity other than the business, like your personal space, your property matters, etc. So various types of mercantile agents can be, first of all, an auctioneer. An auctioneer is a person who has been appointed by the principal to conduct an auction sale, a public auction, and to sell the goods belonging to the principal for some remuneration. So in that case, he also can be an agent for the sellers, for the seller, this principal, and also for the buyer who will be coming in the auction sale to bid and to purchase that auctioned property. And he can also sue for the purchase price recovery from the buyers in his own name. He can personally sue in his own name the buyers who will not pay for the goods that they have bought in auction. Second is factor. Factor is also a mercantile agent. He is the agent who is also given the possession of the goods and to deal with those goods. And he is normally appointed for selling of the goods. And he sells the goods in his own name. And he does not make use of the principal, but his own name is used. And he is not but allowed to barter the goods, or he is not allowed to pledge the goods. He cannot pledge the goods of the principal. And he also has additional property of having a general lien. So if you remember in the topic of bailment, I have discussed with you Bailey's lien of two types, particular lien and general lien. So the general lien was available with some special bailies, and the factor was one of the examples which we discussed there. Next category is del creditor agent. Del creditor agent is an agent who has been given an additional remuneration by the principal so as to get a guarantee from the agent that he will be performing the contract which are given to him in a very efficient way, and the agent guarantees that the performance will be done efficiently, and in case something wrong happens, like some bad debts happen, then the agent will have to bear those bad debts himself. He cannot pass on the loss of bad debt to the principal, because in this case he is being given additional remuneration and additional del creditor commission. So these are the del creditor agents. The other agents who are not the del creditor agent, They do not bear this bad at loss themselves. They pass on the loss to the principal. Fourth is broker. Broker is a person who is not given possession of the goods. He may be buying the goods on behalf of the principal also. He may be selling the goods on behalf of the principal also. But he will not be having the possession of the goods. He will only be a connecting link between the principal and the third party. He will bring together those parties, and then the sale and the purchase will be carried out by both those parties, the principal and the third party themselves. So he will only be a connecting link or an intermediary, and for his services he will be given a brokerage, which is also the commission. Commission agent is somewhat same as the broker is. Commission agent is a person again who purchases or sells the goods on behalf of the principal, and he can also conduct the transactions in his own name, and he may or may not have the actual possession of the goods. So in case of broker, broker will never have the possession of the goods, but commission agent may have the possession of the goods, or he may not have the possession of the goods. So somehow they both are similar. Banker. A banker can also be an agent. So we all know that bank performs certain primary functions, certain subsidiary functions, and certain agency functions. The prime functions of a banker is to accept deposits from the customers and then to give loans to the customers. Besides that, bankers also perform some other agency functions like collecting our bills on our behalf, bills of exchange on our behalf, or they may be making some payment on our own behalf. They may be making some purchases of shares on our behalf. So some transactions where banker is giving services and doing something for us for a commission, in that case, banker also becomes an agent. So in certain transaction, banker can be an agent of the customer. The other categories of the agents here will be non-mercantile agents. Non-mercantile agents are those who are not representing us in the business, like counsel, solicitor, our lawyers who are representing us in the court cases. Wife, we have done already in the types of creation of agency, husband and wife, that topic we have done. Guardian of a child can be an agent. He may be representing, like somebody has some kid has been selected for any advertisement campaign, so his guardian, his parents will be working as his agent and will be entering into certain contracts with those ad agencies on behalf of that kid. Insurance agent, we all know that all the insurance policies are to be procured only through the agents, and you cannot do that directly with the insurance company. So those are insurance agent and those are non-mercantile agents. Receiver, official receiver or official assignee, who are functioning when a company, who are functioning when a person gets insolvent. So when you are declared insolvent, all your powers, they go into the hands of the official receiver. So he also becomes the agent of that insolvent person for the dissolution of his liabilities and his assets. Promoter of a company can also be the non-mercantile agent. So these are different types of agents. Next topic is differences between these four aspects. So we have to do these topics very briefly, just for short note questions. Agent and servant. So agent is given certain directions to do something on behalf of the principal, and we believe that servant also does the same. He also follows the instructions of his master, but still both of them, they are not just the same, because agent has certain authority. Some powers also are given to the agent. Servant is not given any power or authority. And other differences can be principal only delegates the authority, then agent has to decide how he has to perform the task assigned to him. Whereas servant is also told how that task has to be done. So no independence is given to the servant. Then the principal will be liable for all the acts of the agent which are done by him in the course of agency. In case of servant, the employer or the master will be liable for all the wrongful acts of the servant that he has done while he was working under him as a servant. in his employment. Then agent can strike contracts on behalf of principal with the third parties. Servant has no such authority that he can make contracts in the name of principal, in the name of his master with the third party. Second is agent and bailee. Agent and bailee are different in the sense bailee is always given possession of certain goods. Some transfer of delivery of goods has to be there. Then bailee may be given the goods for the purpose of bailment, for the benefit of bailer or for the benefit of bailee, or he may be given the possession of the goods to do something on behalf of the bailer. So in that case, bailee also becomes an agent. But in case of agency, he may or may not be given any bailment of the goods. So that way, both these things differentiate. Also, agent works in representative capacity. He is a representative of the principal, whereas bailee generally is not the representative of the bailer. Third is agent and trustee. So trustee is the caretaker of a trust. A trust has been created and that trust is taken care of by a trustee. Agent and trustee appear to be same, that trustee has to work on behalf of the trust for the benefit of the beneficiaries, like a trust which is looking after an orphanage. Then agent is not the agent and trustee are not the same, because trustee can use all his powers in his own name, whereas agent has to do all the tasks in the name of the principal. Trustee is to look after the benefits of the beneficiaries of that trust. In case of agent also, he is also supposed to take care of the interest of the principal, so that way they connect with each other. So otherwise, both of them, they are not similar, because trustee and agent, both of them, they have representative character. That way they are similar. Then comes agent and independent contractor. Independent contractor is the one who is given certain directions and control, but the agent in that case will be doing everything as per his own understanding and whatever way he wants to do. But in case of independent contractor, he does not merely undertakes to perform that task, he will also use his complete discretion to do the way he wants to. Whereas the agent is supposed, and he is bound by the limits or the restrictions imposed on him by the principal. So he is not that free to do what he wants to do, whereas independent contractor is doing everything independent. Also, independent contractor has no authority to bind the principal for his acts, whereas agent binds the principal for whatever he is doing in the course of agency. So that way, these are the little differences between these terms, and it may be a short question. Then in the introductory portion of the chapter, we also have these two types of authority. That the agent, he may have two types of authority. He may be given an express authority as per contractual terms, clear terms, written or spoken words. He was given what authority, what powers he has to undertake the job given under the agency contract. Or he will also have certain implied authority, which was not given to him expressly, but it is implied that he has all those powers also. So such implied authority cases may be he is given a task. To complete that task for the purpose of agency, whatever is necessary to do lawfully, he can do that. Although he may not be given express power to do that, but it is understood that he has to undertake all those necessary lawful things. Then he also can perform all those justified things which are required as per customs of the trade. There are some trade practices, there are some traditions of a business. So whatever is required in the customary practices of any trade or business, those things can also be done by the agent, even if the express authority was not indicated. Thirdly, we also have discussed earlier, in case of emergency, agency by necessity. So when there is emergency, he may perform some other tasks also, which were in the best interest of the principal. They also come under his implied authority. It is implied that to protect the interest of the principal, he will do some task implied. So this is a short topic of express and implied authority. Now let us move on to the long answer type topics. First one is relation of principal and agent with the third parties. What kind of relation will be there between these two persons and also with the third party? Relation inter se between themselves and relation with regard to the third parties with whom the agent is going to formulate contract on behalf of and in the name of the principal. So in that case, it is said, it is a rule which says that whatever is done by the agent, it is believed that it is done by the principal himself. Agent is doing all these tasks, but we'll presume that these tasks are done by the principal himself. So it does not make any difference whether the act were done by principal personally or through his agent, because agent is also doing those tasks in the name of the principal. Then when agent is doing all those tasks using the name of the principal, tasks or jobs are done by the agent with the third parties. He's entering into transactions, he's undertaking certain projects, he's doing certain duties, etc. So whatever is done by the agent, for all those tasks, the accountability and the liability falls on the principal and not on the agent. Agent is doing, but liability falling on principal. So that will happen in case the task done by the agent is within his authority. It is not beyond his authority. He's not doing anything unauthorized. Secondly, he was doing it with the consent and knowledge of the principal. And thirdly, if he has done something beyond his authority, the principal has ratified them. Principal has approved those unauthorized tasks also. Then in all these cases, principal becomes bound for the acts done by the agent. So the further detail about this topic will include first rights and duties of the principal. So what are the rights of the principal in regard to contract of agency? Rights are, first of all, he can ask for the detailed account of the transactions entered into by the agent. And he will, if he comes to know that some secret profits were earned by the agent in the course of agency, he can demand the payment of those profits. We have discussed about secret profits already in the rights and duties of agent. Second right is, in case because of the negligence of the agent or because of lack of skill of the agent, the principal has suffered some losses, then he can seek the damages or compensation for the same. Thirdly, in case the agent has acted for himself and he has not used the name of the principal for agency transactions, then the principal can also claim non-payment of commission, and he can also ask for indemnity of losses, if any, because of this thing done by the agent. Coming to duties of principal, the duties of principal are the same which we have discussed under the topic of rights of an agent. So they were covered under the section 222 to section 225. Now coming to the position of principal and agent when we talk about the third parties. So position of principal and agent means that when the agent is dealing with the third parties in the name of the principal, who will be liable? So that depends upon three different situations. First, when principal has been named, when the agent was making these contracts or deals with a third party, he has told the existence and name of his principal. Then what happens? Second, in case he has disclosed about the existence of the principal, but his name was not revealed. Or thirdly, when agent was doing all those agency transactions without disclosing that there is some principal existing, without disclosing about either the existence or the name of the principal. So in all these three situations, the position will change, it will differ. So first we'll take up the position in case of a named principal. So if you have disclosed that he is my principal, I have come here to deal with you for my principal who is so and so person, then the position will be like this. First, if the agent was acting within his authority, within the powers given to him by the principal, then whatever he is doing, good or bad, principal will be liable towards the third party for everything of that sort. But second, in case the agent has done something beyond his authority, something which he was not allowed to do by the principal, in that case, principal will be bound by only that part of the work which was done by the agent within authority. And the other tasks which are done beyond authority, accountability will fall on the agent and not on the principal. But in case authorized and unauthorized tasks, they are so joint that they cannot be separated, then the principal will not be liable for the whole transaction at all. Third is, in case third parties in the course of agency transactions, third party give any notice, any intimation to the agent, it will be presumed that notice given to agent is equivalent to notice given to principal. Means you need not give a separate notice to the principal because it is duty of the agent to pass on all the information to his principal himself. Fourth is liability for misrepresentation or fraud. If while working within the scope of authority given to him by the principal, if agent has done something fraud, some fraud or some misrepresentation, although it is for his benefit, for the benefit of agent, etc., in that case also principal will remain liable. Principal cannot say that this cheating has been done by my agent, I am not responsible for this. He cannot do this. He has to undertake the liability or responsibility for the same. Next is, in case while working in the course of agency, if the agent has committed some torts, some wrongful act he has done, then also liability will be falling on the principal. Then liability of principal by estoppel. We have discussed already agency by estoppel. So it is the same topic, that in case the principal by his words or his conduct, he has made the third parties to believe that agent is working within his authority, then later on principal cannot deny that I never appointed him my agent. Remember that case that we did about the Tehsildar appointed by a landlord and Tehsildar gave the land on rent. So in that case, he cannot withdraw his liability later on, saying that he never appointed that person to do this job. So by his words or conduct, you have made the third party to believe that he has his authority. So in that case, whatever was done by the agent, principal will be bound by the same. Second main category in this position of principal and agent with third party will be in case principal was unnamed. That means the agent has revealed that he is working for somebody who is his principal, but the name of that principal was never disclosed. So in that case also the principal will remain liable, provided principal was in existence and third party was also aware that there is some principal whose name is not disclosed. But in case later on the name is disclosed and the third party has some objection with the name of the principal, so in that case they can even terminate the contract. Third situation will be where the principal was never disclosed. That means agent kept on doing all the agency operations without using the name of the principal and showing to third parties that he was doing it for himself only. So in that case, he has not disclosed the existence of the principal and he has not disclosed the representative character of the agent, that I am the representative of the principal. So he never revealed all this thing. So in a situation like this, principal cannot be held liable. Agent will be personally liable to the third party because third party do not know about the existence of any person called the principal. So in that case, third party can sue the agent in his own name and agent can take legal action against the third party in his own name and principal will not come into the picture. But in this situation, principal does exist, but he was not disclosed before the third party. So because of that reason, undisclosed principal can always come into the picture and he has every right to enforce the contract against the third party. For example, the third party are doing something wrong, they are not paying money for the transaction. So in that case, undisclosed principal can also take legal action against the third party and third party cannot say that this principal cannot take action because he was existing. But what third party can do is, in case the principal discloses his existence and now third party have some objection to that, in that case third party can refuse to continue with the transaction, and then they can say that I have to cancel the contract, I cannot go on because this person is a principal, I never wanted to have any transaction with this person or with this person's agent. Then they have every right to cancel that also. So in the upcoming lecture, we'll be talking about the position of the agent with regard to the contract of agency and third parties. Thank you.